Okay, we're talking about attorneys and who that is. These are members of the bar, is who we're talking about, and who that is. This is actually a quote from former Chief Justice of the U.S. Supreme Court, Earl Warren. Quote, between 75 to 90% of all lawyers are either incompetent, dishonest, or both. Um, and so this is actually taken from Book 7 of Corpus Juris Secundum, Section 4, Attorneys. And Corpus Juris Secundum, for anybody that doesn't know, is a set of books in any law library. It's about 150 volumes and basically goes through and explains the law. Anyways, he is, however, in a sense, an officer of the state with an obligation to the court. So the attorneys are working for the court. They're an officer of the court and they work for the court. His first duty is to the court and to the public, not to the client. And whenever his duties to his client conflict with those as an officer of the court in the administration of justice, the former must yield to the latter. And so he's not working for you. He's working for the client. Or I should say, he's not working for the client. He's working for the court. And, that's why they want to get you a lawyer because it's, is it really justice? And I intend to show that it's not. Clients are also called wards of the court. This is all found in the same book. And what's a ward of the court? A ward of the court is an infant or person of unsound mind. Their rights must be guarded jealously. Yeah. And that's Black's Law Dictionary, 4th edition. And so when you hire an attorney, think about it. When you hire an attorney, you're saying that you want to turn yourself into a ward of the court, and a ward of the court is an imbecile. A ward of the court is not competent. Everything is about competence and incompetence. That's why they're representing you, because you're not competent to make decisions for yourself. Therefore, the attorney's going to make decisions for you. There's no such thing as an incompetent sovereign. Do you know who you are? And this is what's going on, is these attorneys are representing you, and the Supreme Court has said there's no taxation without representation, as found in the presentation on corruption in the courts, number 3, the video on that, and also in the peace officers video, and also it's going to be in the upcoming Canada Border Pigs video. And so they want to get these attorneys, well, we're going to go into it further, who these attorneys are. So now we know that only a ward of the court has an attorney, an imbecile, someone who's not competent. This is actually taken from Black's Law Dictionary, 4th edition. Impropriety persona, in one's own proper person. It is a rule in pleading that pleas to the jurisdiction of the court must be pled in propria persona. In other words, you must do it yourself. You can never do something like that through an attorney, because if pleaded by an attorney, they admit the jurisdiction. As an attorney is an officer of the court, he's presumed to plead after having obtained lead, which admits the jurisdiction. So that's why they want to give you a lawyer, because that gives them jurisdiction. And so then they can move right along with their little commercial transaction. The controlling rule is that absent a knowing and intelligent waiver, no person may be imprisoned for any offense unless he was represented by counsel at his trial. So that's what they want to do, is they want to give you a lawyer so they can get you in their jail and make some money. And here's another one. When the trial of a misdemeanor starts, that no imprisonment may be imposed, even though local law permits, unless the accused is represented by counsel. It's exactly what's going on. They want to get you a lawyer so they can put you in jail and make some money. The practice of law cannot be licensed by any state. The practice of law is an occupation of common right. That's one of the things that they want to tell you, is you're not allowed to practice law without a license. Well, I'm sorry. First of all, practicing law means you're selling it, means you're representing someone else. And there's no such thing as incompetent sovereign, so I would never do that, quite frankly. But anybody can do it if they want. A retainer is a sum of money paid by a client to secure an attorney's availability to work for a client. The fee paid is considered earned at the time of payment, because the attorney is entitled to the money regardless of whether he actually performs any services for the client, and the funds shall not be placed into the attorney's trust account. And this is Baranowski versus State Bar. This is a California case. And the Washington State Bar News Committee reports a formal opinion, number 173. And so the point is that if you give them a retainer, then you just flush that money down the toilet. And again, I mean, think about it. You just said you're an imbecile and you want to turn yourself into a ward of the court. So, I mean, why wouldn't the attorney just take it and do whatever he wanted with it? Inns of court. Black's Law Dictionary, 5th edition, page 709. These are certain private, unincorporated associations in the nature of collegiate houses located in London and invested with the exclusive privilege of calling men to the bar. And so, exclusive privilege of calling men to the bar, okay? So this is, and it's located in the city of London, okay? Now, we're talking about the Inns of Court is a private, collegiate, unincorporated association. It's completely private, and all of these bar members are foreign agents of the Inns of Court, and the Inns of Court is actually owned and operated by the Vatican, and I'm going to show that right now. There's an American Inns of Court Foundation. Every state has local Inns of Court chapters. This is their website, and it talks about American Inns of Court. I mean, go check out their website. City of London. What's the City of London? See, there's these Inns of Court. Is where are they located? They're located in the City of London. This downtown London is walled in approximately 1 to 2 square miles. The Imperial Parliament buildings are located in the City of London. The City of London was never conquered by William the Conqueror, and so the City of London has several gates, which is one of them is called Temple Bar. And the only true law schools where they teach 800 years of jury trial decisions in the world are found in the City of London. Inns of Court is one of those law schools. And so the City of London is foreign territory to the rest of England. During the convening of the Imperial Parliament, the Queen gives a throne speech. The Queen goes to Temple Bar and requests permission to enter the foreign territory. The Lord Mayor grants permission. The Queen then walks 2 steps behind the Lord Mayor with her head bowed while she's in the City of London. And because of the fact that the City of London's foreign territory and they may not let her get out of there, what happens is they leave a hostage to be kept until the Queen is released. And the hostage is held in custody by the Queen's agents, I guess, at this Temple Bar. Anyways, this is taken from Concessions of England to the Pope, 1213. Look it up. It says, we'll establish a perpetual obligation and concession. We'll establish that from the proper and especial revenues of our aforesaid kingdoms, and for all the service and customs which we ought to render to them. Okay, customs. Remember, what's customs? Customs is what goes on at the border. Saving all things, the penny of St. Peter. The Roman Church shall receive yearly 1,000 marks sterling, namely at the feast of St. Michael, 500 marks, and at Easter, 500 marks. And then they say 700 for the Kingdom of England and 300 for the Kingdom of Ireland. And that's the concessions of England to the Pope. So King John in 1213 pledged allegiance to the Pope and agreed to pay him tribute. That's what that is. That's exactly what it is tribute. After the concessions of England to the Pope in 1213 was signed, King John had to make money to pay his tribute. King John imposed martial law rule and started to do things to raise money to pay his tribute. And it took only 2 years for the people to figure out what was happening, and the Magna Carta was the result. Quote, the Magna Carta is not a unilateral act emanating solely from the spontaneous will of the king, as the charters of the predecessors of John, neither is it a treaty, for we cannot say it was concluded between 2 legitimate and independent sovereignties, nor between 2 nations, nor is it a law. The barons do not appear in it as subjects, for they are freed from their promise of fidelity, and the king brought captive, placed before them, submitted to the conditions which the conquerors imposed upon him. Magna Carta is therefore a contract, but resembles a treaty concluded between 2 nations, in that one of the parties, in virtue of the law of war, can impose its will upon the other. And that is a Canadian court case in Quebec, believe it or not. And so Magna Carta is a common law writ. There's some really important things to point out about this. Magna Carta is a common law writ, and they say Quebec is under civil law. Well, you know, they wouldn't be talking about Magna Carta in Quebec if common law wasn't there. And this is located at 4 Dominion Law Reports, page 147. And so what they essentially did is they went and stuck a sword to his throat, and they said, "Here, King, we want you to sign this." And they were going to either going to sign it or they're going to run us through. And the city of London shall have, oh, this is actually sections taken out of the Magna Carta to show that they were imposing martial law. And the city of London shall have all its ancient liberties and free customs, as well as by land and water. Furthermore, we decree and grant that all other cities, boroughs, towns, and ports shall have all their liberties and free customs. So they were, what King John was doing was putting people at the borders like they do today, and harassing people and assaulting people and demanding money and all sorts of things like they do today. Section 23, no village or individual shall be compelled to make bridges except those who from old were legally bound to do so. And so they were using their martial law and forcing people to make bridges. Section 24, no sheriff, constable, coroners, or others of our bailiff shall hold pleas of our crown. Well, gee, that sounds like what a cop does on the side of the road today. Section 28, no constable or other bailiff of others shall take corn or other provisions from anyone without immediately tendering money therefor, unless he can have postponement thereof by permission of the seller. So they were stealing people's property, and they don't do that today, but don't give them any ideas. Section 30, no sheriff or bailiff of ours or other person shall take the horses or carts of any freeman for transport duties against the will of said freeman. So they were taking people's horses and carts and calling it transport duty. Section 31, neither we nor our bailiff shall take for our castles or for any other work of ours wood which is not ours against the will of the owner. They were stealing people's wood. Section 38, no bailiff for the future shall upon his own unsupported complaint put anyone to his law without credible witnesses brought for their purposes. So, gee, that sounds like a cop does on the side of the road today. They put you to their law, their contract, or their commercial law. And if you have any doubt about that, watch the presentation on peace officers and watch the presentation on corruption in the courts, number 3, and it goes through it in great detail, and the upcoming presentation on corruption in the courts, number 4. And so that's exactly what they're doing today, and that's section 38. Section 40, to no one will we sell, to no one will we refuse or delay right or justice. Section 40, well, what do you think goes on in the courts today? They want a filing fee for this, and they want a fee for that, and they want a fee for transcripts. They want this and they want that. They're selling all of that stuff, and they're refusing their justice if you don't pay the fee. And that's actually an excise tax. It's all about taxes. It's all about raising money. I had a Texas court to go to the Court of Appeals. They wanted $5,000 to pay some clerk to put together the appeal record in the Texas District Court, and that's going to be part of a Fire the Whores in Texas presentation coming up. The Crown is a corporation that is domiciled in the City of London. The Crown is owned and operated by the Vatican. The crown that belongs to the Queen has ER transposed over it, which stands for Elizabeth Regina. I don't know how many of you have seen that, but I have. All members of the bar are foreign agents of the Crown. They're foreign agents of the Vatican. That's exactly what's going on. There's a Article 13, an amendment. If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept and retain any present, pension, office, or emolument of any kind whatever from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them or either of them. And that's the true Article 13, an amendment that's taken from a certified copy of an 1819 Constitution. Now, bar members, consider the source, have said that Article 13 wasn't approved and adopted, but it's interesting to note that it made its way into an 1819 Constitution because and Virginia statutes in 1819, and And it's also interesting to note, and I brought this up in my first U.S. Supreme Court case, is that the Crown orchestrated the War of 1812 because they wanted to facilitate the disappearance of this Article 13 and Amendment, because one of the major engagements was when they went to the Capitol and burned the archives in the Capitol. And the archives is where the ratification records would have been kept. And now a bar member is telling us that it wasn't properly ratified. Well, why are we not surprised about that? An office of trust is one that requires an oath of office. An office of profit is one which is paid. And so it talks about that. It talks about if any citizen shall accept, receive any title of nobility or honor. Okay, so think about it. A title of nobility, we're going to go into that, or honor from a foreign power is the City of London and the Inns of Court is clearly a foreign power. And the title of nobility, that's exactly what they're getting. And so anyways, let's keep moving. The War of 1812, I brought this up, and the U.S. Department of so-called Justice, which is what I call them in the case, waived their right to respond. In other words, they said, so what? We know about that. The War of 1812 was initiated by the Crown to eliminate the true Article 13 and Amendment. One of the major engagements was when the British burned the Capitol and the National Archives. The National Archives would have been where the ratification records would have been kept. And now are we surprised that bar members are coming out and saying, oh, that wasn't properly ratified? Gee, what's wrong with that picture? All bar members have a title of nobility. All bar members have a special privilege or honor from a foreign power. All bar members have an emolument from a foreign power. A title. Titles are distinctions by which a person is known. The Constitution of the United States forbids the tyrant or any state of any title of nobility. Titles are bestowed by courtesy on certain officers. See, even the president receives a title, excellency, judges and members of Congress, honorable. Why do you think they call them honorable? That's a title of nobility. Members of the bar and justices of the peace are called esquires. And that's Bouvier's Law Dictionary, 1856 edition. An emolument is the lawful gain or profit which arises from an office. An esquire is a title applied by courtesy to officers of almost every description, to members of the bar and others. In England, it's a title next to that above a gentleman and below a knight. Why do you think they want to call you sir in a court? Because they want to give you a title. It's all about titles of nobility. It's all about the Vatican. Don't get me going. All bar members have renounced their U.S. citizenship as contemplated by the Founding Fathers, pursuant to the true Article 13 Amendment. So that's why they went and criminally converted citizenship into the opposite of what the Founding Fathers intended. All bar members represent you in a court. All bar members make legal determinations for you. If you hire an attorney, you're saying you're not competent. If you hire an attorney, you're making yourself a ward of the court. If you hire an attorney, you're saying that you're an imbecile. The right to be represented exists only in a military court. This is taken from Title 10, United States Code. The accused has the right to be represented in his defense before a general or special court-martial or at an investigation under Section 832 of this title. They cannot put you in jail unless you have an attorney representing you. When you hire an attorney, you volunteer to go to jail. We hold that no person may be deprived of his liberty who has been denied the assistance of counsel as guaranteed by the Sixth Amendment. The denial of assistance of counsel will preclude the imposition of a jail sentence. That's U.S. Supreme Court. Argersinger versus Hamlin, 407 U.S., 1972. Almost all judges are bar members, state and federal. This is taken from Title 28 United States Code, so federal judges are all bar members. No individual may be appointed or reappointed to serve as a magistrate judge under this chapter unless he's been at least 5 years a member in good standing of the bar of whatever state he's in. Canada, the same thing's going on in Canada. No person is eligible to be appointed a judge of a superior court in any province unless, in addition to any other requirements prescribed by law, that person is a barrister or advocate of at least 10 years standing at the bar of any province. And the superior court is superior court of general jurisdiction. There's two kinds of courts, superior courts and inferior courts. And that basically means Queen's Bench in Canada, or a court of appeals. Bar members have infiltrated our courts and are now found at every organization in the country and at the highest levels of government. Obama's a bar member. The leader of every major corporation is either a bar member or they surround themselves with bar members. Bar members have criminally converted citizenship into the opposite of what the founding fathers intended. And this is the U.S. Supreme Court again. And while the 14th Amendment does not create a national citizenship, it has the effect of making that citizenship paramount and dominant instead of derivative and dependent upon state citizenship, unquote. So what they're saying is prior to the 14th Amendment, a U.S. citizen was derivative and dependent upon being a state citizen, and subsequent to the 14th Amendment, it was paramount and dominant. And so therefore you can be a U.S. citizen without being a state citizen, and then you read the court cases what a U.S. citizen is. I mean, you don't want to go there. And this is another U.S. case, U.S. versus Rhodes. The amendment reversed and annulled the original policy of the Constitution. They criminally converted citizenship into the opposite of what the Founding Fathers intended. Bar members have converted a U.S. citizen into a slave. Therefore, the U.S. citizens residing in one of the states of the Union are classified as property and franchises of the federal government as an individual entity. A U.S. citizen, upon leaving the District of Columbia, becomes involved in interstate commerce as a resident, does not have the common law right to travel of a citizen of one of the several states. Now, and so, you know, there's lots of court cases that talk about this. Bar members are facilitating the murder of millions of unborn children. This is that celebrated Roe v. Wade case. As used in the 14th Amendment to the United States Constitution, the word person does not include the unborn. Well, you know, and so given the fact that the person under the 14th Amendment is a slave, then how could the unborn be included in that? And that gives them justification to murder them. Lincoln was a bar member. This is a U.S. Senate report number 93-549, dated November 19th, 1973. Quote, since bar members have facilitated the imposition of martial law rule, quote, since March 9, 1933, the United States has been in a state of declared national emergency. Under the powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel, and in a plethora of particular ways control the lives of all American citizens. A majority of the people of the United States have lived all their lives under emergency rule for 40 years. Freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. Quote, next to revenue, taxes itself, the late extensions of the jurisdiction of the Admiralty are our greatest grievance. The American courts of admiralty seem to be forming by degrees into a system that is to overturn our Constitution and to deprive us of our best inheritance, the laws of the land. It would be thought in England a dangerous innovation if the trial of any matter on land was given to the Admiralty. And this is a U.S. Supreme Court case, 1852. And I'll go into this martial law a lot more. I have a martial law presentation, and I'll make a video on that, and you can see what's going on there. Bar members have brought us martial law rule as described in the presentation on martial law, and this is taken from the Revised Code of Washington. Legislative RCW 1.16.090, Legislative Declaration for Civil Liberties Day of Remembrance. Yeah, right. The Day of Remembrance for Civil Liberties, the day that you can remember that we once had liberties. The legislature recognizes that on February 19, 1942, the President of the United States issued Executive Order 9066, which authorized military rule over civilian law and lives. Bar members have brought us color of law, as prescribed herein, as well as in the color of law presentation and the corruption court presentations. Color means an appearance, a semblance, or a simulacrum as distinguished from that which is real, a prima facie or apparent right, hence a deceptive appearance, a plausible assumed exterior concealing a lack of reality, a disguise or a pretext, that's taken from Black's Law Dictionary 5th edition. Colorable means that which is in appearance only and not in reality what it purports to be, hence counterfeit, feigned, having the appearance of truth. Color of law means the appearance or semblance without the substance of legal right, misuse of power possessed by virtue of state law and made possible only because wrongdoer is clothed with authority of state as action taken under color of law. An unconstitutional act is not law. It confers no rights. It imposes no duties. Affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. U.S. Supreme Court. And so, positive law actually is specifically adopted by proper authority for the government of the United States. And so you go into the Office of Law Revision Council, which is a U.S. Congress website, and they tell you that only some titles of the United States Code are considered positive law. Absolute nullity is an act that is void because it's against public policy, law, and order. The nullity is non-curable. It may be invoked by any party or by the court. This is the Office of Law Revision Council. It says, and if you look at the highlighted part there, it says the other titles of the code says, first of all, it says the following titles of the code have been enacted into positive law. And look at how many there is. There's probably half of them that are not positive law. The other title of the code are prima facie evidence, and that means at first appearance. Bar members have brought us color of law. The non-positive law statutes or titles of the code are Title 6, domestic security. Gee, that sounds like homeland security. And yet that doesn't stop them from assaulting you at the border, does it? Title 8, aliens and nationality. Title 12, banking. 15, trade and commerce. 19, customs and duties. 20, education. 21, food and drugs. I mean, most of the stuff, it wouldn't apply to anybody that lives here unless there's some contract. Title 24, hospitals and asylums. Title 25, Indians. 26, internal revenue. Labor. Most of this stuff really wouldn't apply to anybody unless there's a contract. And so it goes, these are all the non-positive law statutes. The code is only prima facie evidence of the laws of the United States, where an inconsistency between the code and the statutes at large appears. The statutes at large prevail over the code. And so what they do is they make a bunch of statutes and then they codified it into a code, and the code's not passed by Congress, and so the statutes are all that's there. You got to understand also that Congress is not the original Congress that was set up by the Constitution and the Civil War. What they did is they did an act for to create the District of Columbia, government for the District of Columbia, and that's what Congress is doing, or 99% of what Congress does is under that. And so, anyways, we'll keep going here. It is well settled that the code cannot prevail over the statutes at large when the two are inconsistent. The provisions of the code are merely prima facie evidence. Look it up. Congress, claiming its martial law power to declare war, suppress insurrections, and repel invasions, imposed martial law on the United States and never discontinued it. The result was an extension of military power and municipal jurisdiction of Congress. But where's the evidence of this? Look at the 13th Amendment, the Civil Rights Act, the legal tender laws, the 14th Amendment, etc., etc., etc. And this is taken from a book called The Non-Ratification of the 14th Amendment that was written by this Judge A.H. Ellett of the Utah Supreme Court. And it's also found in Diet versus Turner. It's an established fact that the United States federal government is dissolved by the Emergency Banking Act, March 9, 1933, Public Law 89-719, declared by President Roosevelt being bankrupt and insolvent. Joint resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States and the official capacities of all United States governmental offices, officers, and departments, and is further evidence that the United States federal government exists today in name only. That's U.S. Congressional Record, March 17, 1993. And this is actually taken from Dun & Bradstreet's website, and it shows there's a United States of America 4 Corp. Well, think about it. That means the first 3 were liquidated in bankruptcy, and we're on number 4. The 14th Amendment is an extension of the national military powers presently used in a municipal character and enforced by municipal laws, stretch far beyond their original limitations and enforced by Article 1 tribunals. And again, that's the same, taken from that same book, The Non-Ratification of the 14th Amendment. Tribunals all come from canon law in the Vatican. Tribunals are military courts. And this is taken from the Code of Canon Law, and it starts talking about tribunals. And it's all coming under Roman civil law is what that is. And this is some more stuff taken from that non-ratification of the 14th Amendment. And this is talking about income tax. And, quote, as we have said, the federal personal income tax is collected under a military venue within a martial law jurisdiction. Federal Reserve notes are military scripts circulated within a military venue. The problem is that people don't understand how the entire United States is covered by a military venue. Under the Social Security Act that was brought into existence, 10 federal regional areas. These 10 federal regional areas are the same as a military base. It is not unconstitutional to circulate military script on a military base, as the base is considered to be a military venue. Military script cannot circulate in the civil jurisdiction of the several states. To get around this constitutional bar, the Congress, via the Social Security Act, created 10 military venues called federal regional areas. The problem the Congress realized was Congress could restructure the government agencies into these federal regional areas. The people could not be identified to be within this military venue, but by their own consent. You had to consent. The solution was to create another military venue which would trick the people to voluntarily accept recognition that they are within the military venue. Congress solved this problem by creating the zip code. The zip code divides the United States into 10 military venues called national areas. When a citizen receives mail from an agency of the federal government and the return address of the federal agency is the district within the regional area the letter is sent from, is there some reason why you think that they're sending mail from another state to you all the time? It never comes from the same state. Anyways, when a citizen receives mail from an agency of the federal government in the return address, the federal agency is a district within the regional area the letter is sent from, and on the address of the citizen it was sent to is the national area in which he received the correspondence from the IRS. In other words, the correspondence was sent from one of the federal regional areas, a military venue, to one of the national areas, another military venue. Taxing districts are established within one of the federal regional areas, which places the collection of taxes under a martial law jurisdiction. You know, they lay awake at night dreaming this stuff up. All courts are territorial courts. This is U.S. Supreme Court again. United States District Court is not a true United States court established under our Constitution, Article 3, to administer the judicial power of the United States, but was created by virtue of the sovereign congressional faculty granted under Article 4, Section 3, of making all needful rules and regulations respecting the territory belonging to the United States. And it's actually territory or other property of the United States. And if you read that article, and and it's all UN. It's all tied into UNIDROIT, and we'll go into that, or we certainly cover it in the corruption in the courts number 3. So if you have a wonder about how the UN is tied into it, go to corruption in the courts number 3. It goes into it in great detail. We might in this one, I can't remember if I have that covered here or not. Quote, in other words, when state martial law is imposed within the state to impose national martial law, Congress has no reason to exercise its martial law powers. If a state is conformed to the new order, there is no need for Congress to intervene. And if a citizen has not obtained the standing of a former slave by petitioning Congress for admittance to venue and jurisdiction of the 14th Amendment, then Congress has no power over that individual under this clause. And again, that's taken from that non-ratification of the 14th Amendment by Judge A.H. Ellett. Quote, when a state forms a constitution which is approved by Congress, it is a stop to deny its validity. The action of Congress cannot be inquired into, for the judicial is bound to follow the action of the political department. Okay, that's U.S. Supreme Court, 1849, and that's what they're saying is that's why the U.S. Supreme Court won't overturn the 14th Amendment as being unconstitutional, because they cannot they cannot question that. And if Congress, it's part of the Constitution. So Congress has said that it's ratified. They lied, but the courts can't dispute it. Rule 45, all courts are actually coming from the President. Anything from the U.S. Supreme Court comes from the President of the United States. All process of this court issues in the name of the President of the United States. So that's the U.S. Supreme Court's bought and paid for too. Over the years, the people have had great trouble accessing the judicial power of the courts, since martial law suspends the judicial power along with all other regular powers of government. This is quite understandable. Congress's power is, practically speaking, unlimited, where the regulation of courts subjected to martial law rule are concerned. Therefore, why would Congress think that their power over martial law measures is limited to the Constitution, especially since Congress claim power under martial law with the power clauses of the 13th, 14th, and 15th Amendments. And that's taken again from the non-ratification of the 14th Amendment by Judge H. Ellett. Quote, it never became a law and was as much a nullity as if it had been act or declaration of an unauthorized assemblage of individuals. And that's exactly what's going on here, okay? These people are just nothing but pirates is what they are. Matter of fact, I don't know how many of you remember those pirates that the U.S. Navy went and captured off the coast of Somalia a few years ago. Well, those same pirates went and they brought them back to trial in New York, and it came out in New York that those pirates were owned and operated by Goldman Sachs. Yeah, they're owned and operated by the bankster thieves. And that's the real problem in all of this. Under the Lateran Pact of 1929, Italy agrees to give the Vatican all the rights of a sovereign nation and to protect the Vatican. Canada, United States, and most other nations have signed on to the Lateran Pact. Under the Lateran Pact, the Vatican is considered neutral territory. Bar members have brought us the UN. All courts in Canada and the United States are United Nations courts under the UNIDROIT Treaty and have been for over 30 years. All courts are de facto courts. There's no authority to delegate anything to the United Nations in the Constitution for the United States of America or the British North America Act, which is the Constitution of Canada. And see Corruption in the Courts 3 and 4. Videos for more information. That goes into that in a lot of detail. UNIDROIT stands for Unification of Private Law, and the website says that 63 countries have adopted it, and it's designed to be automatically implemented. UNIDROIT even talks about municipal law, and remember that non-ratification of the 14th Amendment talks about how they're using municipal law. Canada and the United States have been signatories to the UNIDROIT Treaty for over 30 years. UNIDROIT website says nothing about Texas or Arizona, any of the American states or the Canadian provinces. Therefore, UNIDROIT application in the American states and the Canadian provinces is only in federal areas. UNIDROIT covers negotiable instruments, civil procedures, civil liability, secured transactions, legal status of women, maintenance obligation, contracts in general, banking law, transportation, leasing, franchising, hotels, insurance, and then they make it mandatory, anything related to marriage, divorce, and children, municipal law, and much more. See their website. Think about it. In the courts, you go in there, you have to pay with a negotiable instrument. You do it under the rules of civil procedure. They talk about civil liability. A lot of times in the criminal courts, there's some sort of secured a bond that's issued. A lot of times in the courts, they talk about the legal status of women. They recognize women. At common law, women are the property of the husband, and therefore the courts cannot recognize them. And the maintenance obligations, again, talking about divorce, contracts in general, banking law, again, negotiable instruments, transportation, leasing, anyways, and municipal law. And these courts are clearly UNIDROIT, UN courts. Canada and the United States, actually, we already covered this. Texas is not listed, Arizona is not listed, no American states listed, Alberta is not listed, British Columbia is not listed, Ontario is not listed, no Canadian provinces listed. Therefore, anything involving motor vehicles or the courts is both commercial and federal, and therefore by consent. Now, again, it's talking about, if we go back here, we're talking transportation. It covers transportation, leasing. Okay, so gee, that sounds like motor vehicles. And insurance, and they make it mandatory. I mean, what's wrong with that picture? They go and make mandatory insurance, and then they cover civil liability too. So they want to make sure and generate lots of business. That's what they want to do. Anyways, so this is actually taken from Title 18, United States Code, Section 31. And if all of these actions are actually federal actions, then this applies. And the term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes. And it even defines what commercial purposes is. It's carrying passengers or property for hire. And so if you're not carrying passengers or property for hire, you don't have a motor vehicle. And that cop that stopped you for speeding is shoving his commercial codes down your throat, is what he's doing. Anything in America involving motor vehicles or the courts or banks or finance is actually federal and falls under UNIDROIT. This is a U.S. Supreme Court case. The governments are but trustees acting under derived authority and have no power to delegate what is not delegated to them. but the people as the original fountain might take away what they have delegated and entrust to whom they please. The sovereignty in every state resides in the people, and they may alter and change their form of government at their own pleasure. So the Constitution is a trust indenture with delegated authority. That's the same thing in Canada and United States. And so they only have delegated authority, and that's extremely important. And it's a trust indenture. It says nothing about a corporation. Here's another Supreme Court case. This is Juilliard versus Greenman. This is like the late 1800s. There's no such thing as power of inherent sovereignty in the government of the United States. In this country, sovereignty resides in the people, and Congress can exercise no power by which they have not by their Constitution entrusted to it. All else is withheld. Okay, so again, the Constitution sets up a trust, and it's a delegated authority. Well, a delegated cannot redelegate. An agent cannot delegate its functions. These are fundamental maxims of law that are old as time itself, unless he be expressly authorized to do so. Okay, and so there has to be an express. It has to actually say it. A delegated power cannot be delegated again. A deputy cannot have or appoint another deputy. This is taken from Coke, from all sorts of this is as old as time itself. There's no delegated authority for a corporation called United States or any agency or department or commission, board or other entity of a corporation. As used in this chapter, United States means a federal corporation, an agency, department, commission, board, or other entity of United States, and instrumentality. And that's taken from Title 28 United States Code Section 3002, which means that if you sue the United States, you have to sue the corporation. And there's no delegated authority for that corporation. So they go and drag you into their corporate commercial jurisdiction. They assault you, and then the only way you can get a remedy is go before their corporate commercial UN courts, and they drag you in either one way or the other. They'll either drag you in by the force of arms, or if you want to get a remedy, then you got to go in there. There is no delegated authority for a corporation called the Federal Bureau of Investigation. There's no delegated authority for a corporation called National Security Agency. There's no delegated authority for a corporation called Central Intelligence. I don't remember reading anything in that stuff in the Constitution about that stuff. There's no delegated authority for a corporation called the Department of Homeland Security. There's no delegated authority for a corporation called Internal Revenue Service. There's no delegated authority for a corporation called Department of the Treasury. There's no delegated authority for an agency called the Office of Attorney General of the United States. There's nothing in the Constitution that says anything about this, and unless there's a specific delegation of authority, they don't have any. There's no delegated authority for a municipal corporation called the City of Fort Worth, and that falls under Unidroit, and non-ratification of the 14th Amendment even talks about municipal corporations. There's no delegated authority for a municipal corporation called City of Grand Prairie. There's no delegated authority for any municipal corporation, and all their prisons are municipal corporations, and there's no delegated authority for any of them either. So they put you in their commercial prison so they can make some money. That's exactly what it's all about. A corporation, there's no delegated authority for a corporation called the Department of Public Safety in any state. I don't care what it is. There's no delegation of authority for a corporation called Texas State Police or State Police in any state. You know, if you think about it, you know, after they wrote the Constitution, the Founding Fathers, the federal Constitution actually trumps the state constitutions. Matter of fact, the states have to make their Constitution to conform with the federal Constitution. The courts have ruled that. And what happened, if you think about it, is that after the Constitutional Convention, all of the Founding Fathers went home and wrote state constitutions. And so the federal Constitution trumps them, and so the federal Constitution where this stuff is supposed to be mentioned, and it doesn't say a word about any of them. It does say words. It does say that the states, talks about the states. So the states are authorized. There is a delegation of authority to the states, but it's no delegation of authority to any of these municipal corporations, and they have no authority whatsoever. They're nothing but thieves and pirates. This is taken from Canadian words of phrases decided in Canadian courts. The word Canada is used in Section 91(1) of the Constitution Act, does not refer to Canada as the geographical unit, that's the landmass, but refers to a juristic federal unit. That's a corporation, the usual form of juristic person. The only one in common law is a corporation. There's no delegated authority for a corporation called Canada. There's no delegation of authority for a corporation called Royal Canadian Mounted Police. There's no delegation of authority for the corporation called Canada Border Services Agency, PIGS. Oh, I'm sorry, I didn't mean pigs. Actually, I did mean pigs. There's no delegation of authority for a corporation called Lethbridge Correctional Center. There's no delegation of authority for a corporation called Calgary Remand Center. There's no delegation of authority for any of it. Quote, it is an established fact the United States federal government has been dissolved by the Emergency Banking Act, being bankrupt and insolvent. The joint resolution to suspend the gold standard and abrogate the gold clause dissolved the sovereign authority of the United States. The United States federal government exists today in name only. That's U.S. Congressional Record, March 17, 1993. And so they went and first they set up these fictitious corporations that they have no authority to do, and then they make them bankrupt. And the same thing is happening in Canada. This is actually from the SIN number, social insurance number, instruction sheet. When someone wants to apply for their social insurance number. Anyways, if you're replacing it, you got to pay $10, and you got to make the check for a receivable payable to the receiver general for Canada. Well, think about it. That's a receiver in bankruptcy. So the same thing is going on in Canada. There's no authority in Canada or United States to delegate any power to the United Nations or to any United Nations agency, and all of their unconstitutional delegations of authority are ultra vires and unconstitutional. And this is taken from Black's Law Dictionary 6th edition. It's talking about ultra vires. The term has broad application, includes not only acts prohibited by the Charter, but acts which are in excess of powers granted. Act as ultra vires when a corporation was without authority to perform it under any circumstances and for any purpose. Ultra vires act of municipalities, one which are beyond powers conferred upon it by law. In other words, they don't have authority over any living souls. That's the reason they have to convert you into a fictitious entity, so they can put you in their jail and assault you and justify their assaults and their kidnapping and the judicial whores in these so-called courts. That's all they do, is they sit there and fabricate evidence that you're one of their slaves. This is actually taken from Section 15 of the Criminal Code of Canada. So in Canada, in a way that's probably better, although they ignore it, obedience to de facto law. No person shall be convicted of an offense in respect of an act or omission of obedience to the laws for the time being made and enforced by persons in de facto possession of the sovereign power in and over the place where the act or omission occurs. Well, they do it all the time, and so they just ignore that. But it's there. It's there. There's no doubt about it. When any corporation goes bankrupt, the creditors become the owners, and it is a coup d'etat for the government, except that they don't tell you. And so that's what's happened. So then you think about it. Well, this is actually taken from AMR creditors prefer all-stock merger with U.S. Airways. And if you look at the highlighted stuff at the bottom, we'll zoom in on it. It's right here. As the new owners of a significant percentage of a restructured airline, it is APA's responsibility, and that stands for Allied Pilots Association. So the American Airlines was bankrupt, and Allied Pilots Association was one of the creditors, and so now they become one of the owners. And this is the second page. It talks about under the U.S. Airways proposal sent in November, AMR creditors would own 70% and U.S. Airways shareholders 30%. And so think about it. The creditors would own, because AMR is bankrupt and it's a merger. This is a merger between AMR and U.S. Airways. So the creditors become the owners, and U.S. Airways shareholders. The U.S. Airways is not bankrupt, so the shareholders still have some value that they have. And so anyways, the point is that when any corporation goes bankrupt, the creditors become the owners. So who is the creditors for this corporation called Canada, this unconstitutional delegation of authority that called Canada or United States, that they don't have any authority? They go and make it bankrupt. They deliberately do it so then they can seize it, and then they can impose their martial law jurisdiction. This has been going on for centuries. I mean, hello? Anyways, So attorneys have done this stuff. These United Nations bankster thieves make all the rules and insurance about insurance, negotiable instruments, and banking, etc. These United Nations bankster thieves make it mandatory so they can create this fictitious debt. By fraud, these United Nations bankster thieves create a sesticade trust in the name of every living soul when they're given birth to be used to finance their fictitious debt and to facilitate the slavery of we the people. That's exactly what's going on. These United Nations bankster thieves then seize the corporation when it inevitably goes bankrupt and thereby create their worldwide dictatorship. These United Nations bankster thieves get their whore buddies in the bankrupt legislatures and parliaments because, think about it, they sold themselves to the bankster thieves. These United Nations bankster thieves get their whore buddies in the bankrupt legislatures and parliaments to hire low intelligent pigs to populate border crossings so they can assault people and kidnap people and falsely imprison people to create business for their so-called courts, to generate business for their bankster owned and operated prisons, and to generate revenue to support the fictitious debt. That's exactly what's going on. These same United Nations bankster thieves create a fictitious war on drugs and a war on illegal immigration and a war on terror and a war on anything else they can think of, all as which is really wars on we the people, to justify their hired thugs at the border and to further make business for their kangaroo so-called courts and to make business for their bankster owned and operated prisons. These de facto kangaroo United Nations courts make sure they get a conviction so they can make business for their bankster-owned and operated de facto prisons. These de facto kangaroo United Nations so-called courts have a conviction rate that is over 97%, and if you do not plea bargain it, they throw the book at you just like they did to me. They want a plea bargain because the plea bargain cannot be appealed. The crimes of bar members are too numerous to list. Bar members have converted our nation from a Christian nation into what that it was intended to be, into a nation of hedonists and devil worshippers. They've taken God out of our schools and out of our courts. The number one export of the United States is entertainment. Think about it. We're hedonists. Is there any wonder why Christ had such complete and utter contempt for the attorneys of his day? It's just amazing to see that the people allow this to happen. And so that's attorneys, and I hope you enjoyed it. I want to encourage you to watch some of my other videos. I'm going to be doing, I've got them already done actually, but they're as part of private information shares, and now I'm going to do them independently. And so you'll be able to watch them as I upload them. This one is about bar members. There's actually things that I could add, but I didn't want to make it too long. And so, but this will get you going. These bar member thieves, they're all foreign agents of the Vatican, and we need to, the Founding Fathers knew the threat that they offered, and they tried their best to solve that problem, but obviously they weren't able to do it.